friend.
Hello, friend. Welcome back. Let me be honest with you about something. Back in June 27th to be exact, the Supreme Court issued a decision that fundamentally changed how our government works. And I completely missed it. You probably missed it too. Most people did. It wasn't because we weren't paying attention. It's because it was buried in a case about birthright citizenship that was wrapped in legal jargon about equitable remedies and something called the Judiciary Act of 1789. And it got delivered in a way that made it sound like boring procedural stuff that only law professors care about. I only found out about it back in October when I was looking for potential episode topics. And here's the thing. Even with tools I specifically built to catch buried institutional stories, this took months to surface. So I, like many creators, leverage AI in my process. And I've got this AI agent whose whole job is to scan political news for exactly this kind of thing. It goes out and it looks for important stories that get buried. And it came back to me with 3 options, and this was option 2. And I'm reading through the summary thinking, wait, what? The court did what in June? So I went down the rabbit hole. I read the actual Supreme Court opinion, all 40-something pages. I read the dissents, started pulling Congressional Research Service reports, looked at what legal scholars across the spectrum were saying. I even talked to a couple lawyer friends. And here's what I found. On June 27, 2025, the Supreme Court quietly eliminated one of the primary tools federal courts use to check presidential power. And almost nobody noticed. Not the people who should be worried, and not the people who should be celebrating. Not because it wasn't important, but because it was buried. Again, it was buried in a case about birthright citizenship. It got wrapped up in legal jargon about equitable remedies and the Judiciary Act of 1789. And it got delivered in a way that made it sound like a boring procedural tweak. But this wasn't a procedural tweak. This was the Supreme Court using its own power to limit lower courts' power to check the president's power. That's a paradox that should concern everyone. And I mean everyone, regardless of which team you're on. So let me explain what actually happened, why it matters, and here's the twist, why this might come back to bite the people who are celebrating it right now. Quick background. You might remember that on day 1 of his second term, which was January 20th, 2025, President Trump signed Executive Order 14160. It's officially called Protecting the Meaning and Value of American Citizenship. But what it actually does is it attempts to end birthright citizenship for children born in the United States if their parents are undocumented immigrants or here on temporary visas. Now, there's this little thing called the 14th Amendment to the Constitution, which says, and I'm paraphrasing, if you're born in the United States, you're a citizen. Period. It's been that way since 1868. Legal experts across the political spectrum, conservative, liberal, libertarian, you name it, pretty much all agree this executive order is unconstitutional. The Ninth Circuit Court of Appeals said so explicitly back in July. Multiple district courts actually agreed. But here's where it gets interesting. When Trump issued that executive order back in January, 3 different federal district courts, one in Maryland, one in New Hampshire, one in Washington State, did what courts have been doing for the past couple of decades. When they think the president is doing something illegal, they issue nationwide injunctions. What's a nationwide injunction? It's exactly what it sounds like. A federal judge says, this policy you're trying to implement, you can't enforce it. Not just against the people who sued you, against anyone, nationwide. Full stop. Until we figure out if it's actually legal or not. It's a big hammer. And for the past 20 years or so, it's been the main way courts can stop a presidential policy in its tracks while litigation works its way through the system. But on June 27th, the Supreme Court said that hammer, you don't get to use it anymore. Justice Amy Coney Barrett, writing for the 6-3 majority, said, federal courts don't have the authority under the Judiciary Act of 1789 to issue injunctions that protect anyone beyond the specific plaintiffs who filed the lawsuit. So now, if you sue the president over an unconstitutional policy and you win, the court can protect you. But your neighbor who didn't sue, they're shit out of luck. The government can keep enforcing the policy against everyone else. Here's where this gets really interesting. In the first 100 days of Trump's second term, so January 2025 through April 2025, federal courts issued around 40 nationwide injunctions blocking his policies. In the entire 20th century, there were 27 nationwide injunctions. 27 total. Let me say that again. More nationwide injunctions in 100 days than in 100 years. So what changed? Well, both parties discovered this tool and they weaponized it. The pattern is almost comically predictable. California judges blocked Republican presidents. Texas judges blocked Democratic presidents. Rinse and repeat. Under Bush and Trump's first term, most nationwide injunctions came from California courts. The Northern District of California alone issued 15 blocking Trump policies. Under Obama and Biden, Texas judges led the pack. 58% of nationwide injunctions against Obama came from Texas courts. Both sides were forum shopping, finding friendly judges in friendly districts to block policies they didn't like. And you know what? I get why people on both sides found that frustrating. It was being abused. A single district court judge in Hawaii or Texas probably shouldn't be able to set national policy just because they disagree with the president. But here's my question. Was the solution to eliminate the tool entirely? Or was there a middle ground we just drove past at 80 miles an hour? And here's where this gets concerning. I can hear some of you saying, good, federal judges were overstepping. This restores the proper balance of power. And look, I understand that argument. There's a real concern about judicial overreach. Nobody elected district court judges. They shouldn't be making national policy from the bench. But let's walk through what this decision actually does in practice. Before June 27th, the president issues potentially unconstitutional executive order. An advocacy group sues. A federal judge says, this looks illegal. Nobody can enforce this anywhere until we figure it out. The policy gets blocked nationwide while litigation proceeds. After June 27th, the president issues a potentially unconstitutional executive order. An advocacy group sues. A federal judge says, this looks illegal. I'm protecting the specific plaintiffs who sued. Everyone else, the policy still gets enforced against them. So the president can issue an order that multiple federal courts have said violates the Constitution. And as long as he's okay with narrow injunctions protecting just the people who sued, he can keep enforcing it against the other 330 million Americans. Think about that for a second. The government can lose in court, have a federal judge rule their policy is illegal, and nothing really changes for 99% of the population. Now, the Supreme Court left one door open. Class action lawsuits. Justice Kavanaugh in his concurrence basically said, hey, you can still file statewide, region-wide, or even nationwide class action lawsuits and get the same effect. And within hours of the Supreme Court decision, and I mean literally the same day, advocacy groups had filed motions to certify nationwide classes in the birthright citizenship cases. By August, 2 different courts had certified those classes. So the workaround exists for now. Here's where Justice Alito steps in with a warning. He wrote a concurrence joined by Justice Thomas that essentially says, district courts better not think they can use class actions as a loophole to bring back nationwide injunctions. If we see that happening, we'll tighten up class certification rules too. And if the Supreme Court decides to crack down on class actions, that affects way more than just challenges to executive orders. That's consumer protection class actions, civil rights class actions, employment discrimination class actions, environmental class actions. The hammer might not just hit government accountability, it could hit private accountability across the board. Let me try something here. Forget about Trump for a second, forget about Biden. Forget about which policies you support or oppose. Imagine you work for a company. Your company has a CEO who issues a new policy that the company's own compliance department says violates federal law. Several employees sue, and 3 different judges in 3 different states all rule, yeah, this policy is illegal. We're ordering the CEO to stop implementing it. But the CEO says, you know what? I'm only going to follow those court orders for the specific employees who sued. Everyone else, policy stays in effect. What would you call that? I'd call it flouting a court order. I'd call it a CEO who thinks the rules don't apply to him. But when the president does it, when the executive branch loses in court, but keeps enforcing against non-plaintiffs, we're calling it what? Respecting the limits of judicial authority? Does that pass the smell test? Now flip it. Imagine a future where a Democratic president issues sweeping executive orders on climate regulation, gun control, or labor rights. Conservative groups sue in Texas. A Texas judge says, this is illegal, I'm blocking it. But the judge can only block it for the specific plaintiffs. The president keeps enforcing everywhere else and declines to appeal because, hey, they got 95% of what they want. Would conservatives be comfortable with that? Would they say, well, the Supreme Court was right to limit nationwide injunctions? Or would they be screaming about executive overreach and courts being hamstrung? The principle has to work regardless of who's in power. That's the whole point of having principles. Why this could backfire spectacularly. Here's the irony that I can't stop thinking about. The conservative legal movement spent years, decades really, fighting nationwide injunctions. They hated when California judges used them to block Trump policies during his first term. The Federalist Society held conferences about it. Vice President Pence gave a whole speech in 2019 announcing they were developing a strategy to attack the legal basis for nationwide injunctions. They won that fight. On June 27, 2025, they got exactly what they wanted. But here's the thing about eliminating a tool for checking executive power. It doesn't just limit this president, it limits every future president. So when Trump leaves office, whether that's in 2029 or later, and a Democrat takes over, conservative litigants are going to face the exact same constraints. Under the old system, Texas judge blocks Democratic president's immigration policy nationwide. Policy can't be enforced anywhere. Supreme Court has to weigh in quickly. Under the new system, Texas judge can only block it in Texas, or for specific plaintiffs. Democratic president keeps enforcing in the other 49 states. Administration doesn't appeal the narrow ruling because they're fine with that outcome. No Supreme Court review. Examples of policies conservatives might want to block nationwide if a Democrat wins in 28 or 32. Aggressive climate regulations affecting businesses across all states. Expansive interpretations of civil rights laws. Labor regulations, gun control executive actions, healthcare mandates, education policies like Title IX interpretations. Good luck stopping any of those with plaintiff-specific injunctions. You just gave away the tool you'd need to fight back. Justice Sotomayor warned about this in her dissent. She said the executive branch can now lose in court, but still enforce against most people by simply not appealing narrow injunctions. It's reverse forum shopping. The government picks and chooses which losses to accept and which to fight based on whether the loss is narrow enough to live with. That power doesn't care which party you belong to. It just cares who controls the executive branch. I want to give you both sides here because this isn't clear cut. Professor Samuel Bray from Notre Dame Law School, he's a conservative legal scholar, leading expert on this issue, argues that Article 3 of the Constitution limits federal courts to providing remedies only to plaintiffs who have standing to sue. Federal injunctions should be, quote, no broader than necessary to protect the plaintiff from injury. He published influential articles arguing nationwide injunctions' lack of historical foundation. From his perspective, the Supreme Court got this right. District judges were overstepping. This returns the courts to their proper constitutional role. On the other side, Professor Mila Sohini from Stanford Law School, she's a progressive legal scholar, and she wrote that the decision's methodology and conclusions are myopic and wrong. She says, quote, especially unwelcome during a period in which each passing day seems to bring new incursions by the executive branch upon individual rights, the separation of power, federalism, and the rule of law. The court just proclaimed a diminution of judicial remedial authority at precisely a moment when that authority is needed urgently. From her perspective, the Supreme Court just hamstrung the judiciary's ability to check executive power when we need that check the most. Both of these people are brilliant legal minds. Both have legitimate concerns grounded in constitutional theory and practical consequences. And here's what I can't get past. They're both right. Nationwide injunctions were being abused. Forum shopping was a problem. A single district judge probably shouldn't set national policy. And eliminating the remedy entirely makes it functionally impossible to stop a president from enforcing unconstitutional policies against most Americans while litigation drags on for years. So we had a problem. We chose to solve it by removing the judicial check almost entirely, and we're calling that balance. Here's something that's been nagging at me. The Supreme Court's reasoning in this case was all about originalism and historical tradition. Justice Barrett said nationwide injunctions, quote, lack a historical pedigree and weren't part of English equity practice at the time of the founding in 1789. Fine. I'll accept that. It's most likely historically accurate that the founders didn't specifically envision district courts issuing nationwide injunctions. But you know what the founders also didn't envision? A president who issues 209 executive orders in 9 months. A massive administrative state with dozens of federal agencies. Executive orders that affect 330 million people simultaneously. Global enforcement of immigration policies. Instant nationwide communication of policy changes. The whole reason nationwide injunctions became common in the past 20 years is because presidential power expanded to a scope that the founders never imagined. If we're using 18th century equity principles to limit judicial remedies in the 21st century, shouldn't we also be using 18th century limits on executive power? Because right now it looks like we're saying presidential power, expand to modern scale, issue nationwide policies affecting everyone simultaneously. Judicial power, to check that, constrained to 18th century equity principles. That's not balance. That's putting your thumb on the scale in one direction. And before anyone says, well, Congress can check executive power, have you seen Congress lately? When's the last time Congress effectively checked presidential overreach from either party? The courts were the functional check. And we just dulled the blade. Look, what I want to be clear about, this decision isn't the end of the world. The workaround exists. Class actions can achieve the same nationwide effect if courts certify nationwide classes. And so far, they have. The birthright citizenship cases showed that advocacy groups adapted within hours. File a class action, get it certified, protect everyone in the class. Functionally the same as a nationwide injunction. Professor Sohini from Stanford said the decision, quote, could have been far worse, and noted that because class action workarounds exist, the ruling might turn out to be essentially academic. So maybe this is all much ado about nothing. Maybe the new system will work just fine, but Justice Alito's warning is sitting there like a ticking time bomb. If the court decides that district judges are abusing Rule 23 to bring nationwide injunctions back through the class action door, they can tighten those requirements. And if they do that, it won't just affect challenges to government policies. It'll affect all class actions. Consumer protection, product liability, employment discrimination, civil rights, environmental cases. The remedial tool millions of Americans rely on to hold powerful entities accountable could get significantly weaker. We won't know for a few years whether courts will make class certification easy or hard in these cases. We don't know if the Supreme Court will intervene again to close the loophole. But the uncertainty alone is concerning. Because constitutional rights shouldn't depend on hoping judges continue to creatively work around Supreme Court decisions. Let me make this concrete. What this means for you, the real stakes. Under the old system, if the president tomorrow issued an executive order that violated your constitutional rights, and an advocacy group sued on behalf of people like you, a federal court could block that policy from being enforced against anyone while the case worked its way through the courts. You were protected even if you didn't personally sue. Under the new system, if the president tomorrow issued an executive order that violated your constitutional rights, a federal court can only block it if you specifically are named a plaintiff in the lawsuit, or if you're part of a certified class action that hasn't been challenged yet. If you're not a plaintiff, if you don't have the resources to hire a lawyer, if you're not part of an organization that can file a class action on your behalf, the government can keep enforcing that unconstitutional policy against you for years until either you personally sue or the case reaches the Supreme Court and gets resolved definitively, which could take 3, 4, 5 years. Constitutional protections now have a 2-tier system. Tier 1, people who can afford to sue or who belong to organizations with legal resources. Tier 2, everyone else. Does that seem right? How long until this changes? I asked a legal scholar friend of mine, how long would it take for the Supreme Court to reverse course on this? Her answer? Look at history. Plessy v. Ferguson established separate but equal in 1896. It took 58 years to overturn it with Brown v. Board of Education. Roe v. Wade was decided in 1973. 49 years later, it was overturned with Dobbs. Chevron deference was established in 1984. It took 40 years to overturn it last year with the Loper-Bright. Most major Supreme Court precedents that get overturned take somewhere between 50 and 60 years to reverse. The median, probably 40. Now, this case is a little different because it's based on statutory interpretation of the Judiciary Act, not constitutional holdings. That means Congress could fix it legislatively. They could amend the Judiciary Act to explicitly authorize nationwide injunctions. But let's be realistic. When's the last time Congress passed major legislation reforming judicial remedies? And would any party in power want to authorize nationwide injunctions that could be used against their own president? So practically speaking, we're stuck with this for at least a generation, which means everyone celebrating this decision right now better hope their party controls the presidency for the next 20 years, because if power changes hands, and it always does eventually, you just gave the other side the same freedom from judicial checks that you wanted for your guy. So here's what I keep coming back to. The Supreme Court just made it significantly harder for federal courts to stop presidents from enforcing potentially unconstitutional policies. They did it in the name of judicial restraint and proper separation of powers. But the result is that one branch, the executive branch, has more freedom to act, while another branch, the judiciary, has less power to check it. We solved the problem of judges overstepping by letting presidents overstep more easily. I'm not saying I have the answer. I genuinely don't. Maybe this is the right call in the long run. Maybe forcing everything through class actions will work fine. Maybe the workaround becomes the new normal and nothing really changes. Or maybe we just removed one of the last remaining checks on executive power at precisely the moment when both parties keep electing presidents who push the boundaries of what executive orders can do. And here's the twist that should concern everyone. This doesn't care about your politics. This doesn't care which team you're on. If you're cheering this decision because it helps your preferred president right now, ask yourself, are you going to be comfortable with this when the other party wins? Because they will win, eventually. That's how democracy works. And when they do, you're going to want the courts to be able to stop unconstitutional executive actions quickly and effectively. But you just gave away the tool that let them do that. So my question, the one I genuinely don't have an answer to, is this. When we look back 20 years from now, are we going to see this as the moment we restored proper judicial restraint? Or are we going to see this as the moment we accidentally gave every future president a blueprint for how to keep enforcing illegal policies by just accepting narrow losses and avoiding the Supreme Court? And if it's the latter, what do we do about it then? Now get off my lawn.
Hello, friend.